Radi. Dobar dan, dame I gospodo, ladies and gentlemen. Well, this conference actually is the most vibrant we had to date, I think, since these conferences started, which is a very good sign for the future of mining in Serbia. We have heard, actually, today that mining is contributing to Canada 55 billion per year, that Australia is taxing 12 billion in 2015 to 2016 of taxes, that at this moment in time we have about 130 exploration fields active, and that basically all of those fields are privately financed in Serbia. Therefore, you know, we have heard also that the law is probably the best in Eastern Europe, the 2015 law. But things were not like this 5 years ago. 5 years ago, the situation was different in the sense that there were plans to introduce a mandatory equity of the state in private projects in the law. So that has actually awakened the then existing exploration companies and the embassies to try to defend the privacy of the projects. That was a completely different time than today. And I'll just give you a brief account of how things went in the last 4 or 5 years since that moment, for example, which was 2012, 2013, and then how I see that the project should be definitely legally secured, the tenure of the investment should be secured, and how this should be done, what is the critical path to do so. So in 2014, the private industry has established the Geological Mining Association, GRAS. And that actually association served as a conduit between the private industry, private exploration and mining companies, and the government. And that has proven to be a very good vehicle, a very workable vehicle, which has produced good results. And the most important result was the new 2015 mining law. We really heard very good commentaries on that law. It is much better than was the case with the 2011 law. There is still ample space for improvement, and we have ideas how it could be improved, but obviously this change of 2015 has served its purpose. We have extended the exploration terms from 7 years to 12. We have secured tenure in the sense that the 2015 law has for the first time given the right of conversion from exploration to mining. Before, that was not secured in the law. It was a euphemism saying like, the investor may apply for an exploitation permit, may apply. It didn't say has the right. Now, the law of 2015 says the exploration permit holder, actually the state certificate of reserves holder, obtains the exploitation permit. So that is a critical change in the law. We have introduced expropriation in favor of private investment. We have reduced the scope for arbitrary powers of the state. And this is all very good, but we need to have subordinate legislation, podzakonska akta, need to be completed under the law by December 2017. And there is some issues that need to be resolved, and GRAS is offering its kind services to assist the government in resolving those issues so that we have modern, new subordinate legislation following a modern law. If the government wants to improve more, we have a lot of ideas which could add to the efficiency of the processes and simplify the processes for for quicker development, for quicker permitting. That is regarding the mining law. There are talks that the Ministry of Finance is preparing Zakon o naknadama za korištenje dobara od opšteg interesa, something like that, Zakon o naknadama. That is something that we need to follow closely as the industry, because we have currently the royalties regulated in the mining law, which are, I think, well balanced between the interests of the state and the industry. So we should take care that the situation is not deteriorated by passing a new law on Zakon o naknadama, the law on some compensations, right? Also, another thing has been a major development. That was the investment law. And I have also been personally involved in that with the Ministry of Economy. A new investment law has been passed, and several important novelties have been introduced in that law. And one of them is the introduction of working groups between the state and the investors. Another thing is an expedited procedure for all investments, that all permits will be issued at the fastest possible pace according to the law. And that was the first time an expedited procedure was introduced. That was also my idea, also like the working group. Also, that law, investment law, guarantees compensation in case of expropriation under very limited, internationally recognized situations when expropriation is accepted. Then there are other laws also guaranteeing the rights of investors, which is the general law on property, then the laws on agricultural land, law on forestry land, environmental protection laws, spatial planning laws. All those laws contain certain promises to investors, certain promises that if the investors meet certain requirements, submit certain documents, that they will get certain rights. That is very important, those promises. Mind this, I'll come to it later. Then the Serbian state must also fully understand that the companies sitting in this room are FCPA compliant, Foreign Corrupt Practices Act, which is the first law in the world, which was extraterritorial to prevent any kind of bribery and under-the-table dealing. And Canada has a similar law, and all important countries have similar laws with extraterritorial impact. So this is very important to understand, that the companies themselves, under their own home country legislation, but also that their investors, like the large investment funds, who work and finance the mining companies, also have very stringent rules of prudency and cleanliness in doing business. That is very important. Another level of talking about protection is the BITs, bilateral investment treaties, which Serbia has a multitude of. One of them being with Canada, another one being with the UK, interestingly enough, not with the United States. Those BITs, in the eyes of many lawyers in Serbia, are like Luke water. They're not important. No, 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 they're very important. Serbia has just been paying 40 million damages in an arbitration between the state of Serbia, Bor mine, RTB Bor mine on the one hand, and a Greek company which was whose investment was secured by a BIT with Greece, bilateral investment treaty. So it is a very dangerous document, one which the state should analyze carefully, and all state servants, civil servants, should be well aware of the duties which and the liabilities which the state has undertaken in case of violating, for example, the fair and equitable treatment clause, or the full legal security clause, or the non-discrimination clause. So that is a very important aspect. And I'll just give you one important point. When you choose...
Sorry for interruption. Just this case you're speaking, the arbitration case, it was not exit case, but it was investment arbitration between Greek investor and Republic of Serbia about Bor.
It was not under the exit rules.
It is UNCITRAL rules, to the best of my knowledge.
UNCITRAL rules,
yes,
okay.
Because it was one of the choices on the bilateral investment treaty. But the Bor was not, RTB Bor was not the party. It was directly between Serbia and the investor.
I see.
And this is very dangerous definition for the state, not for the investor, what the investment really is. But sorry, just for clarification purposes.
Good, thank you very much. So those bilateral investment treaties are a very important vehicle of protection of investment, and everybody should be aware of those. Now, all these rules that I have just talked about give a very solid, at this point in time, and I'm emphasizing the moment, at this point in time, give a very solid legal basis for doing mining in Serbia, exploration and mining. You have security of tenure, you have most of your rights guaranteed under those several levels of rules. Now, you remember the famous sentence of Winston Churchill, when he said, the British Parliament can change everything except a man into a woman. Times have changed, and now you can change man into woman, women into man. So everything can be done by Parliament, which means that there is the general principle of sovereignty, and the state can change its laws. So the laws which you have presently in place may not be there in 3 years, or in 5 years, or in 25 years, and your operation may last 100 years. So the current situation is very good, but we need to fix it in time. We need a legal stability on the long term, which is not secured by the laws themselves and the statutory promises contained in them. Like if you do that, then you will get a mining permit. That can change in time. And you have already made the investment, serious investment, but the laws, the spirit of the times have changed, you know, closed societies, communism, Bolsheviks come, who knows what. And you know what happened in 1917 to all Western investment in Russia. So we need investment agreements. We need investment agreements. And the definition of an investment agreement is something basically unknown in Serbian law as an independent agreement. You had elements of investment agreements in the existing joint venture agreements between the Serbian state as a joint venture partner and large foreign investors like Fiat, like Gazprom, like Belgrade waterfront contract and so forth. So those were typically joint venture agreements where Serbia invested something, the investor invested something else, and they have secured certain stability provisions regarding the law and the fiscal aspects. But you don't have a real, just classical investment agreement where the state acts in its sovereign capacity to guarantee stability of law and fiscal rules in time, and a private investor who is not a joint venture partner to the Republic of Serbia. So I have worked on that a lot, and there is a basis for that. There is a strong basis for that. Actually, in the provisions that I have suggested to the government regarding the mining law, there was an entire clause for investment agreements. They have declined to put it both in the mining law and in the investment law, but there is a general basis for such an agreement in the fact that the government may sign agreements and commit the Republic of Serbia as its agent. Second thing, you should be careful to pick a home jurisdiction with a good bilateral investment treaty. Just to give an example, for example, the British Virgin Islands are not covered by the BIT between the UK and Serbia. The British Virgin Islands are not part of that BIT. So it's not good to have a British Virgin Islands parent company, because it's not covered by the BIT. You need one like Holland, which is good. Canada is okay, but Holland is better. A good BIT to cover your rights, to protect you. A BIT is a very complex legal animal, hard to understand if you don't understand a number of issues. You need to understand the Serbian government. You need to understand Serbian law. You need to understand the needs of the mining companies long-term, thinking of it 50 years in advance. Then you need to understand international investment law in detail, meaning knowing the arbitration practices, because there is always a tension. There's always a tension in those arbitration cases between states and investors. Where are the rights of the investors justified to be protected, and what is an excessive narrowing of the sovereignty of the state? One must know how those arbitrators think to draft clauses which will protect the investment but not transgress the minimum of sovereignty which most of the arbitrators would accept in such arbitration cases. one has to look into the precedents of the Serbian state. It's very important to understand what the Serbian state has already accepted and use those precedents as argumentation between in negotiations. And I'll just give you a brief content of a mining investment law as I see it, as investment mining law. You need, of course, the definition of the parties. You need the purpose of the agreement. You need an elaborate clause on cooperation between the investor and permitting. You need an elaborate clause on the use of land, lease of land, and land ownership in respect particularly to mining land. You need provisions on special purpose spatial plan, on the development of infrastructure, on fiscal stability, on maintaining a legal framework in time, but not to say we're fixing the whole legal system of Serbia. No, you have to focus on those provisions of those laws which are really reasonably important to the existence and subsistence of the investment. Then a confidentiality clause, an indemnification, very concrete indemnification clause in case of violation of the agreement. Then a clause referring to public announcements, representations and warranties naturally. A good governing law and dispute resolution clause, which will attach this agreement to the bilateral investment agreement. A waiver of sovereign immunity clause, generally boilerplate clauses, and appendices which would be elaborate. So with this, I thank you, and I'm open to your questions.
Hvala puno, Milane. Pošto polako ulazimo u cajtnot sa vremenom, a verujem da su i svi nestrpljivi jer ručak je već poslužen, pokušat ćemo da ovaj panel održimo u razumnom vremenu, ali ipak smatram da treba da se čuju još neke stvari izuzev pravnog okvira za investiciona ulaganja, a to je ono što bar klijente koji dolaze kod nas u kancelariju najviše interesuje, to je poreski tretman i pitanje poreza. Zbog toga je danas sa nama Igor Lončarević. Igore, izvoli.